Thank you, everybody, for taking time out of your day-to-day to join us. We're very excited to have Tori with us today to talk about the new regulations and the new policies under the Massachusetts Environmental Policy Act. And before we jump into the main portion of the program, we just have some housekeeping to do. Sarah, if you could jump to the next slide. Thank you. So we want to say a big thank you to our annual event sponsors, First Light Power and Robertson and Cole. A lot of this programming wouldn't be possible without our annual sponsors, so a big thank you to them. And if you're not too familiar with Zoom, I think a lot of us are at this point, but just in case, you'll see some buttons at the bottom of your Zoom screen. For this session, we're going to be using the Q&A box at the bottom. If you have any questions you want to submit, and we'll pose those questions after sort of the main part of the presentation. We will not be using the chat box for that purpose, so please make sure to put your questions into the Q&A, and that's where we'll see it. Next. A couple of upcoming events we want to make sure you're aware of. We have our next Ask Me Anything coming up, or AMA, and that will be on March 9th from 4 to 5 p.m. And that one will be featuring Sabrina Edinger from Piper Maddox, and she's an energy storage manager there. And those are always really good conversations. So we hope you can join us for that. And following that, we have our big 2022 NEWIEE Annual Awards Gala coming up on April 28th. From 6 to 9 p.m. We are planning to be in person back at the Westin in Copley Square in Boston. And obviously we'll be following all COVID protocols that are in place at the time. You can check out our website for more information on both of those events and for more information about the COVID protocols as they stand currently. And with that, we will move over to the main part of the program. So big thank you to Tori for joining us today and taking the time to give us some more information and details about the regulations that have recently rolled out in December. As you may know, Tori is the director of the Massachusetts Environmental Policy Act Office and the Assistant Secretary at the Executive Office of Energy and Environmental Affairs for the Commonwealth of Massachusetts. Thank you again, Tori, for joining us today, and I'll hand it over to you for the presentation.
Okay, great. Thanks for that introduction, Vivian, and thanks to NEWIEE for the opportunity to present today on the new regulations promulgated in December of last year. So the regulations are an important first step in implementing new requirements relative to environmental justice included in the climate legislation passed in March of 2021. So I'll be using a slide deck today that we compiled upon the completion of our regulatory review effort last year, hence the date on the slide deck. This is already posted and available on the MEPA website. The slides will go over the key components of the climate legislation as related to the MEPA review process and describes how we have incorporated those statutory requirements both into our regulations and 2 new protocols that took effect in January of 2022. I also want to take the opportunity to thank the members of the MEPA Advisory Committee, which includes many of your members as well, such as the 2 major utilities. The Advisory Committee was formed in September of 2021 to provide broad stakeholder input into our regulatory review process. And it really truly has been an invaluable source of both historical knowledge of MEPA regulations and practice and innovative ideas for future revisions. So I anticipate there'll be quite a few questions today, so I will go over the slides relatively quickly, so there'll be an opportunity for questions at the end. Next slide, please. So as many of you are aware, we did launch our regulatory effort in February of 2021. This was even before the climate legislation was passed in March. We outlined as our primary goal alignment with state policy and planning efforts in 3 key areas, which always included environmental justice. However, with the passage of the climate law and the very tight timeframe of the end of 2021 given to the MEPA office to promulgate regulations, our focus very much shifted to implementing those statutory mandates. But now that we have completed our first phase of regulatory revisions, we do intend and are already engaged in what we're calling our phase 2 regulatory review effort that's looking at the entirety of the MEPA regulations. And in addition to reconvening the MEPA Advisory Committee, we're also partnering with the Mass DEP, the Department of Environmental Protection, on their effort to develop what's called a cumulative impact analysis approach to air permitting. This was also a mandate under the climate legislation and has some overlap with the new EJ analysis that we put out at MEPA. We're hopeful that DEP's process will result in some new methodologies that could be used to refine those new EJ protocols that I'll be describing today. Next slide, please. So just to start off, just a quick overview of the MEPA review process, which many of you, I'm sure, are old hat at. The basic rule, of course, that for projects requiring MEPA review is that the project both have an agency action, which is typically a state permitting action, and one or more of these review thresholds are exceeded. These are levels of environmental impacts that are set out in our regulation and determines the level of review that is required for the project. So the higher level review, higher level impact would require a higher level of review through MEPA. The core requirement of the climate legislation essentially changes the familiar dichotomy between what's called the ENF level review, which is typically a 30-day review upon the filing of an environmental notification form, and those correspond to the so-called ENF thresholds in our MEPA regulations. And the so-called EIR review, which begins with the filing of an ENF in a 30-day review period, but extends to 2 additional rounds of review based on the filing of a draft and final EIR, or environmental impact report. And so those are, of course, correspond to what we refer to as the mandatory EIR thresholds in our MEPA regulations. So under the core provision of the climate law now, for projects that are located near EJ populations, it is now an automatic EIR review. That is the big change that was made and that I'll explain in greater detail today. Next slide. So moving on to the climate legislation itself, there are 3 key sections that relate to MEPA that we've now incorporated into our new rules. Section 57 requires now that all EIRs filed with the MEPA office address the public health impacts of the project in addition to its environmental impacts. So this is a new requirement that applies to all EIRs, not just those filed for projects near EJ populations, but it is a new important requirement that it was added to the MEPA process. Next slide. Now, Section 58, this is that core provision that I alluded to earlier that adds this new EIR requirement for projects located near EJ populations. So it essentially requires that lengthier EIR review process for projects that are located in what's referenced as the designated geographic area around EJ populations. So that's either 1 mile of an EJ population, any project located within 1 mile, or 5 miles if the project impacts air quality. Now, we have defined that phrase, impact air quality, in our regulations to mean either the project exceeds one of our air thresholds for stationary sources, or is anticipated to generate mobile source emissions of 150, associated with 150 diesel generated vehicles per day or more over the duration of 1 year or more. So if those criteria are met, then any project that's located within 5 miles of an EJ population is now subject to the new EIR requirement. Now, the law also uses the phrase likely to cause damage to the environment. So it's not all projects, but only those that are likely to cause damage to the environment. However, that's a phrase that is used in our MEPA regulations to essentially refer to and define those review thresholds. So we read this language to mean that a project that exceeds any of our existing MEPA review thresholds, either those lower level ENF thresholds or the higher EIR thresholds, are now required to go through an EIR process if located in those designated geographic areas around EJ populations. However, we've also made clear that we don't read this language to mean that more projects will need to be filed with MEPA, because it did not change the basic jurisdictional rules around agency action and the need to exceed those review thresholds. So a project must be otherwise required to file with MEPA and otherwise meet those jurisdictional rules that are laid out in our regulations. But if it does so, then it must undergo an EIR process, again, if it's located in those designated geographic areas around EJ populations. Now, once the EIR is filed, it must contain certain content that's also laid out in the legislation. So the analysis follows essentially a two-step process. The project must first assess the existing conditions within those identified EJ populations to identify any existing unfair or inequitable environmental burden or related public health consequence. And then if there is an indication of such existing burdens, then the project must identify whether the additional impacts of the project will create a disproportionate adverse effect on those EJ populations or increase or reduce the effects of climate change. That's a lot of words, and I'll get into more of that as I explain how we have opted to incorporate these requirements into our regulations and protocols. Next slide. So finally, Section 60 of the legislation refers to the public involvement requirements, and it requires the EEA secretary to enhance public involvement opportunities for EJ populations for those projects in those designated geographic areas. And I'll explain in more detail as I get into the protocol how we have chosen to implement this particular section. Next slide, please. So moving on, I will now describe both our regulatory approach and then those two new protocols. In terms of the new regulations, the full text is now available. It's all on our website, and we have a full page on our regulatory review process. The first two bullets here refer to those mandated components that I described earlier that are in the legislation itself. So of course, number one is adding that new EIR requirement, and indeed the legislation uses the phrase EIR shall be required. So we very much felt like we were constrained by the legislative language here, and there was no other way to interpret this other than that the EIR process is required for those projects in those designated geographic areas. And then number two, we've put into our regulation what the EIR must contain following that two-step assessment process that I alluded to earlier, both the assessment of existing burden and then the assessment of the additional project impacts. Now, the one area, however, that the MEPA office does have some discretion is in determining the precise review procedures that would be warranted for these new types of EIR. So that is what's referenced in that third bullet. And here, as we were thinking through this, this aspect, we were very much cognizant of the fact that this new EIR requirement will be a big change for the majority of projects that are filed with MEPA. So based on some statistics that we pulled, we estimate, based on the number of filings in the last 2 years, that a good 80% of our new project filings fall in that ENF only category that are exceeding those lower level ENF level thresholds. But nonetheless, a good portion of those projects, 60 to 70%, will have to go through an EIR process because they're located near EJ populations. We're also cognizant of the fact that we do get a wide range of projects, and some of them are very, very small, down to small single family homes that may not have significant impacts of concern. And it could be that those projects can definitively show that they will not have a disproportionate adverse effect on EJ population. So it is not worth going through a full EIR process with those projects. So with those two factors in mind, what we've done is added some flexibility in our review procedures to allow for some streamlining if those circumstances warrant that type of approach. So there are two forms of streamlining that are now available. One is the so-called single EIR procedure, which was already available under the prior rules. So this would allow a proponent to file an expanded ENF filing and request a single EIR, which, as the name suggests, would allow the proponent to file one EIR document and undergo one review period, as opposed to the typical two-step draft and final EIR process. We've also added a new procedure that we're calling a rollover EIR process. Now, this is an adaptation of another procedure, again, that was available under the old rules. It was available as a project would go from a draft to a final EIR. So the concept is that when a draft EIR is filed, it's otherwise complete, there are no issues remaining to be scoped, then the Secretary has the option of simply publishing that document as is and treat it as the final EIR in the next environmental monitor. So this essentially eliminates the need for the proponent to prepare yet another document and file it as the final EIR. So we've adapted that concept to these new EIRs that are now required for projects near EJ populations. So the procedure here is that for projects that are anticipated to meet the specific criteria that we have laid out in our regulations, it will clearly not have a disproportionate adverse effect on EJ populations. Those proponents will have the option of filing what we're calling a dual filing. So you would file both an expanded ENF to request a rollover EIR process. There's a new checkbox now that we've added to the ENF form, but you'd also file a proposed EIR together with that expanded ENF filing. So upon review of that proposed EIR, if the Secretary determines that the criteria are met, no issues remaining to be scoped, and no disproportionate adverse effect on EJ populations, then she would have the option of rolling that document over into the next available environmental monitor. You'd still have to go through an additional comment period, but there would be no need to prepare another document to be filed with the MEPA office. So that's the basic concepts, and those two procedures are now available both through our regulations and is spelled out in greater detail in our protocol documents. We've also put up some explanatory text onto our website pages where there are those how-to pages around how to prepare the EIR and expanded ENF filing. So practitioners can check out those pages as well. Okay, and then finally here, the regulations also incorporate key elements of the public involvement protocol, including a new 45-day advance notification requirement, which I'll get into in more detail in a bit. Next slide, please. So then moving on to the two new protocols. So the first is the public involvement protocol. And as some of you know, we did put out various versions of this in 2021 and solicited comments from the public. This was also the subject of very robust discussion at the MEPA Advisory Committee. And our ultimate approach here is very much meant to reflect the recommendations and I would say a consensus view among the advisory committee members. At the end of the day, what we've elected to do is to take a broad approach to outreach and community engagement. So while that section 60 of the climate legislation talks about the projects that have negative effects on EJ populations, we think the law also exhibits an intent to increase opportunities across the board for EJ neighborhoods to engage in public review of all projects that are located in those designated geographic areas. There was also robust discussion at the advisory committee about projects that may provide benefits to EJ populations or have a net benefit for the community. And the view was that even for those types of projects, there is a need and a benefit to having more engagement and more public process as a project is reviewed at MEPA. So what the protocol does now is it does add as a requirement for all projects located in those designated geographic areas to engage, to have some form of outreach and community engagement prior to filing with MEPA. The one exemption are projects that are proposing one single family home. Now, having said that, the protocol is not particularly prescriptive on the specific strategies or measures that must be followed. We do lay out a full list of best practices and ideas and suggestions. The one component that is prescriptive is the first bullet here, which is that early notification that I alluded to earlier. So this is a requirement of a 45-day early notice to the community prior to filing at MEPA. Now, we are cognizant that this will add to the permit timeline, so we have endeavored to make this as simple as possible. So the process would be first to obtain what we're calling an EJ reference list. This is a list of local community-based organizations and tribes that have been compiled by the EJ Director of EEA in consultation with the MEPA office. We've created a new email box called MEPA-EJ@mass.gov. So if you send a request to that box with the project location and all municipalities within that designated geographic area, either 1 or 5 miles, we are committing to getting the list out to proponents within 1 to 2 business days. We've also created what's called an EJ screening form. It's attached to the protocol. It's also on our MEPA forms page. So that was our effort to boil down the key facts about the project that should be contained in this notification to the local CBOs and other neighborhood groups. We will be translating that form into multiple languages as a service, and that'll be available on our MEPA forms page as well. So the process is simply to fill out the form, attach it to an email, and send it to that list of CBOs and tribes, in addition to any other groups that the proponent may have identified. We are also offering a transition period. So for projects filed between January 1 and the end of February, we will not strictly enforce that 45-day rule. However, the project will be expected to extend the comment period by at least 2 weeks to allow for additional engagement by any interested parties. But as of March 1, if a project is filed without having done a 45-day advance notification prior to filing, then the project will be rejected. So I just want to emphasize that that is the one prescriptive requirement. It does add to the timeline, so I'd encourage practitioners to keep that in mind as you're moving through permitting. One thing that I would like to emphasize is that the advance notification should not be a substitute for actual and meaningful engagement with the EJ community. So that is a requirement. And we are encouraging and trying to incentivize as much as possible all projects to engage in some form of engagement prior to filing, whether that be a community meeting, advertisements in local newspapers, advertisements in public libraries, community centers, what have you. We are encouraging that type of engagement prior to filing. And then finally here, in terms of languages, there's been some confusion on this point since the protocols were rolled out. I think the key thing here, just from a practical perspective, is that if you look at the EJ Maps viewer that we've put out, there's a languages spoken tab, and that is the tab that should be used. The easiest thing is to simply turn off the EJ layer and to look at the census tracts within the designated geographic area around the site, and it will identify the languages that are identified at a 5% threshold, so 5% or more of the residents are speaking that particular language who do not speak English very well. So the task here would be to essentially translate that EJ screening form into the languages that are identified in that tab, and to include that in that early notification, and to use those languages, offer translation in those languages in any other outreach that's conducted. All right, next slide. So moving on to the second protocol, this is perhaps the more complex of the two. So this relates to how the project should analyze its impacts on EJ populations. And it follows that two-step process that I alluded to earlier. So step one would be an assessment of existing environmental burden. Now, if you look at the language of the climate legislation, it appears to refer to a rather complex and individualized assessment of both historic and current activities related to private, industrial, commercial, state, or municipal operations to determine whether there's an unfair or inequitable burden. We are not requiring that type of individualized assessment for each project site. As some have pointed out, the language of the law does not appear to have any time restriction or any parameters around the types of activities that must be surveyed. What we're doing is pointing to publicly available data sources that could be used to perform this type of assessment, as this is consistent with approaches taken by other states like California, more recently by New Jersey, and also US EPA, that have developed mapping tools for this purpose to assess the level of existing burdens and vulnerabilities of a particular population. So Massachusetts does not currently have such a mapping tool, but there are certain resources available. So the key one that we're pointing to is this DPH-EJ tool that's put out by the Department of Public Health. Among other things, it has 4 vulnerable health EJ criteria that's specific to EJ populations. It was intentionally selected as criteria that are closely correlated not only with environmental factors, but socioeconomic indicators like poverty and minority status. So that's a factor that should be considered in addition to other mapping layers. For example, the number of other DEP permitted air and water emitting facilities, toxics users, proximity to major roadways, et cetera. So this approach admittedly is still qualitative at this stage, and which is why we are looking to that DEP cumulative impact analysis process, where we're hopeful that we can develop more quantitative approaches and more precise approaches later this year. We're also pointing proponents to that RMAT climate tool, which is already a part of the MEPA process. It's a required attachment to the ENF form to assess climate risks. We're also pointing to the EPA EJ screen. This is at the option of the proponent, it's not a requirement, but it is a good resource that's already out there. These are environmental indicators that are organized by census blocks. So you can easily see a particular EJ census block, whether there are elevated conditions based on the 8 or 9 environmental indicators that are included in the EJ screen. And then finally, any other factors that are identified during the community engagement process. So obviously these publicly available sources are only good as the data that's in them. And so if there are particular issues that might be unique to a particular neighborhood or a pocket of the neighborhood of the project site that you weren't aware of, that we are asking proponents to consider that type of input as well. Next slide, please. So moving on, step 2 then would assess the nature of the project's impacts on top of the existing burdens that have been identified. I would say this part of the analysis is a unique aspect of the Massachusetts legislation. So the ultimate inquiry is whether the project will create disproportionate adverse effects on the EJ population. But the focus is very much on whether there's an existing burden in the neighborhood that already could be viewed as inequitable in some respect, and is the project exacerbating those existing conditions in a way that could be viewed as creating a disproportionality in some respect in the EJ population. Now we're asking proponents to consider a variety of factors here. So one is the nature and severity of the project impact. So essentially comparing what you're adding to the neighborhood to the nature of the existing burden that may already exist in that population. Secondly, you would simply compare the project impacts on EJ versus non-EJ populations. Third, we are asking proponents to consider project benefits as well. The one key point that I would raise here, however, is that we're not likely to accept a netting out approach, a net benefits approach, where generalized benefits to the community that a project might offer would be viewed as simply netting out significant and high impacts or new forms of pollution that may be added to the EJ population. But project benefits, certainly particularly environmental benefits that are meant to reduce any existing burdens in the neighborhood, would be a relevant factor here. And then finally, considering climate change effects. And I think the methodology here would largely follow our existing protocols around GHG or greenhouse gas emissions, as well as that climate resiliency protocol based on that RMAT tool that we put out late last year. We are not asking for GHG modeling for every project, only those that will be adding building assets that will be used or occupied by EJ populations. And then lastly, mitigation if disproportionate adverse effects are indeed identified. So again here, admittedly, this step of the process is still somewhat qualitative. We are asking proponents to do a good faith assessment of the project impacts and comparing it against any existing burdens and vulnerabilities that have been identified to assess whether there will be a material change in those existing conditions that could be viewed as disproportionate. So I think, from a practical pointer perspective, I think a lot of the analysis will have to come out through the scoping process. So proponents should expect to see specific issues or specific impacts called out in a scope for the EIR that we would ask for further analysis. So air quality, for example, would be an obvious example. If an EJ population is already burdened with a certain amount of air emissions and air quality issues, then adding new forms of air emissions through traffic, even construction period traffic of a long duration, would be relevant factors. If there is a lack of green space or open space or parks in the area, and the project will be removing tree cover or adding impervious area in a significant way, then that could be an area for scoping as well. Just a few examples there. But again, we're watching that Mass DEP process, and I would encourage all of you to engage in those public stakeholder sessions as well. They've already started mapping out a full list of environmental, socioeconomic, public health factors that could be used to screen as a screening mechanism for those baseline factors in the EJ population. So those types of methodologies could have applications in other contexts beyond air permitting as well. Next slide. So that's the overview of the regulations and protocols. I've said a mouthful, so I'm sure there'll be a lot of questions here. This is just a reminder of where we've been and where we're going. Of course, we did put out the new regulations in December, and we are looking forward to our second phase regulatory review effort as well. Next slide. And then this is just a reminder of ways to participate. Our advisory committee meetings are open to the public, so encourage anyone to attend. We are looking at the entirety of MEPA regulations to see what would need to be updated. Even the EJ rules, as I explained earlier, that EIR requirement does tie to the review thresholds that are laid out in regulation. So we are actively thinking through with our advisory committee, is this the opportunity to perhaps revise or update those basic regulatory thresholds, which would in turn dictate the level of review and the applicability of this new EIR requirement near EJ neighborhoods as well. And then you can sign up for listserv updates, and our website is continually updated as well with developments on this front. So I'll leave it there, and hopefully that leaves some time for questions. And I see there's already some questions coming in through the chat, so I'll turn it back to you, Vivian.
Yeah, thank you. Thanks for giving that presentation, giving us a good baseline to be working from here. So I would just ask everyone, if you've got questions that you'd like us to discuss, if you could put those into the Q&A box rather than the chat box, it just helps us keep track better of what we're asking and what's been addressed. So as you mentioned, we do have some questions coming in. So there are some questions about the public health impact analysis and sort of what's enough, right? Like what level of analysis is expected there?
Yeah, that's a good question. And you know, I will say that the public health piece is you know, is a requirement across the board, of course, not just around EJ populations. And so we did not elect to put out a new protocol just on public health impact. So we are, you know, leaving that largely to the scoping process and asking proponents to think that through. I mean, I think the one thing I will say is we don't necessarily view public health impact to be a separate category apart from environmental impacts. I think we would view that as what are the public health consequences of the environmental impacts that you are already analyzing for the project. For instance, you know, we noted, and there was discussion in our advisory committee that, you know, the section 61 of the statute that talks about certifying that all environmental impacts have been avoided or minimized was not changed. So I think that still the core exercises at MEPA is to analyze the environmental impacts, but this would just mean that you would need to assess what the ultimate public health consequences of those impacts could be. So I think from a practical perspective, point of view, I would say please add a public health section to your EIR documents, and it would just be a more fulsome discussion of any permit regulations, for example, that might be tied to public health risks. So, you know, we get, I know this isn't quite relevant for this crowd, but we get a lot of lab office development proposals, for example, and the issue of laboratory discharge water and where those discharges go is an issue. And so obviously that is would be covered by whatever discharge permits the proponent will need to obtain. But whereas in the past, one might not have had a discussion of that in the EIR, it would just be including that discussion in more detail and describing exactly what the discharge limits are and how that ties to protection of public health. So that would be one example. But again, I think this is an area that will probably need to come out through scoping, and depending on you know, the specifics of the project, there could be specific types of analysis that agencies might ask for, but it will need to be taken up more on a case-by-case basis, I would say.
Great, thank you. There's a lot of questions about greenhouse gases. You mentioned in passing, and I think a lot of folks didn't quite catch it, when is the greenhouse gas study required?
Right, so this would be, so of course, our GHG policy currently requires the compliance with the policy for any EIR project. So I think we haven't read the EJ rules to say now that all of those projects are EIR, all of them will have to comply with the GHG policy. We're reading it because because the ultimate requirement in the climate law is to assess the climate risks on the EJ population. So what we're saying here is that if you're adding a building asset, a building that will be used or occupied by EJ populations, we've also added a tons per year threshold, so we're not catching too many small projects. There's a calculator that's in the protocol where you can just put in your building type in square footage, and it'll just automatically spit out an estimate for you. So only if you are putting in a building asset that's used or occupied, and the estimated GHG emissions will exceed 2,000 tons per year based on that calculator, then you would be expected to essentially follow our GHG policy and undertake that modeling. So we've attempted to narrow the range of projects that would be caught up under the new rule.
Yeah, and for used or occupied, I think
Mhm.
the obvious use case there is residential uses,
Right.
but does that also include like retail or workplaces?
Yeah, we are being inclusive in that regard. I will say, and we did put some language in the protocol in that regard. We have a lot of we have some projects where the EJ population might be a good distance away, like a mile away, and like slices a little corner of the site. So I think what we said in our program is, for the most part, we're talking about projects that are located within EJ neighborhoods. It's closely located to those neighborhoods and sort of surrounded by them. Then you can make a reasonable judgment or inference that they'll be used or occupied. So that's the general use rule of thumb, is if the project site is located within those census blocks, unless there's some other reason to think that there's a particular building, if it's a community center, for example, that will be will attract the neighboring populations, that might be an exemption. For the most part, we're looking at projects located within those census blocks.
That makes sense. Let's see. So there was a question about a website and whether that needs to be set up and be available during the 45-day notice period, or is that sort of something you set up after the filing's actually been submitted?
Yeah, I'm assuming that's a reference to a project website that the proponent would have been. So we're not requiring that. Again, I think that falls in the camp of issues that we would leave to the discretion of the proponent based on the complexity of the project. But if you do choose to set up a website, yes, it'd be great if you could do that within that 45-day. Obviously, the concept is that you're trying to provide as much time as possible for EJ communities to engage with the project. And honestly, for big scale projects where you're out there with all sorts of strategies to communicate with the neighborhoods, the process should start well before the 45-day period as well. But yeah, I've seen big projects that set up the project website. And for instance, there's a recent project where the proponent is preparing some fact sheets, and in the fact sheets are direct links to the project website. And I think they were even using like QR codes somehow to directly link to the website. It was very sophisticated. So that, yes, I mean, that would obviously be the best practice, to set up a website and to direct people to, but not necessarily a requirement under the protocol.
Right. Another question here about methane leaks. It's, I think, not so specifically called out in any of the regulations or protocol, but are those considered impactful on air quality in this sort of context?
Right. Yeah, that's a good question. I mean, we're not including methane leaks unless the extent is so great that it would exceed our air thresholds. We're not including that as a reason to kick out the radius from 1 mile to 5 miles. Those are just based on the air thresholds, which tie to major source stationary emissions or the diesel generated mobile sources that I described earlier. That said, I mean, as a general matter, yes, methane leaks are a source of GHG emissions and other pollutants into the air. So if you are expanding a gas pipeline and expect to generate some new leaks in that area, and you're surrounded by EJ populations, I would certainly expect a discussion of that impact in the EJ analysis section and in the public health section as well. We have not included that in the GHG analysis or asked for specific quantification. But if you're surrounded by EJ neighborhoods and there's an indication of an existing air quality burden, that could be something that we could scope for for that EIR. So it would really depend on the circumstances.
I know there were some other questions that came up in the chat, but unfortunately a little harder to sort through. If folks could, again, drop your questions into the Q&A, that would be very helpful. I know in general there have been questions and discussions about, how do you, in terms of meaningful engagement, obviously the proponents are expected to put in a good faith effort, but there could come a point at which the community feels that it's still not enough, and there's sort of a disagreement about what is quote enough.
Right.
And that may be project by project, but I don't know if there's anything you want to address as far as that goes as a sort of rule of thumb.
Yeah, that's a really good question. It's come up a lot in other contexts as well. It's a tough issue. I mean, the one area that's clear is if the project has made no efforts and it's clear on the record that nothing's been done. We do say in the regulations we can even reject that project as incomplete for not complying with the protocols. But if they've made some efforts, there are obviously projects that do have some opposition from communities, and you may or may not be able to appease that by the time you get into MEPA. I mean, a couple of thoughts on that. One thought that was discussed through the MEPA Advisory Committee is that somehow with the MEPA office together with the EJ office, create some resources through increased staffing of, staff who could serve as sort of a project liaison of sorts. I know some cities and towns do that. Boston has increasingly started to increase their EJ efforts. So, with the idea being that somehow the state would oversee outreach efforts and either approve a plan or kind of sign off on measures along the way. So that's something we are actively thinking through. Reese Reddy, our EJ director, is intending to expand staff to allow for more resources to be directed at MEPA projects. That's more of a long-term measure. So for now, as I said, we're not being particularly prescriptive. We're strongly incentivizing and encouraging projects to engage in outreach. We'll certainly get comments in that regard, but we haven't created checklists or standards to say, either you've met this standard or have not met that standard. The one thing I'll say is, and this was something that was discussed through our stakeholders as well, is it's a bit of a carrot and stick approach, right? If you are able to get out there and get public support for a project, then on the flip side, once you're at MEPA, hopefully the review will go smoother and there'll be a greater foundation on which to grant single EIRs or other expedited procedures. So that is the concept there, but it is a tricky issue. I think, obviously it depends on the analysis as well. So we're encouraging everyone to get out there and do the best you can, but the analysis is analysis. If the project truly has very little impact and it's not impacting EJ communities, there's not too much more the proponent can do. On the flip side, if you are showing some real impacts that are going directly to the EJ neighborhood, then that is something that's the point of the new protocol, is to ask the proponent to really take that seriously and to consider that. And hopefully by really directing efforts there and engaging with the community, the hope is that you'll get some buy-in, before you come into MEPA on some of those issues, so that it doesn't become an issue of whether you've done enough or not.
Yeah, that is certainly the hope, and hopefully that helps smooth permit processes later on as well, even past MEPA.
Right.
Let's see, there were a few questions just about the present. So the recording of this event will be available to registrants who request it. Just send an email to NEWIEE. Also, I believe your presentation deck itself is on the MEPA website. Is that correct?
Yep. Yes, it is. Yep. Yeah.
Great. So you can find it there if you want to refer back to it. Let's see. Trying to search through the chat for questions. I don't think I see anything else in the chat. Certainly there are, I guess there's a question about how the protocols are measured when they're more qualitative, and it sort of sounds like in a lot of cases it's going to be based on scoping, dependent sort of project by project as to whether it's sufficient and whether more needs to be evaluated.
Yeah, I think that's right. I mean, if a proponent wants to try for that rollover EIR, obviously, you're kind of anticipating the scope in a way and trying to put all of the analysis into that initial document. So I think for that reason, it was really intended for projects that are kind of a no-brainer, as it were, right? The key category of projects that were discussed was things like ecological restoration, where the project is intentionally, the whole purpose of the project is to improve environmental conditions. So, there could be some temporary impacts, but the ultimate goal is to improve conditions, or, very, very small projects where the EJ population may be far away and there's just very localized impacts that are not likely to extend out to those areas, could be another example. So, I mean, we are, through pre-filings and the like, we are starting to see examples of those kinds of projects where, this was a bit of a blunt instrument that was put into the law. So we'll definitely have those examples of, does it really make sense to do a full EIR here for this type of project that doesn't seem to have a lot of impact? So that's what that rollover provision is intended to do. But yes, I mean, for the most part, I am expecting that the so-called ENF only projects will increasingly come in at least seeking a single EIR. So, so there'll be an opportunity there for us to scope for those individual impacts. So if it's a request for a single, we are asking at least for that step one baseline assessment to be included in the expanded ENF filing, so that there's a basis for us to then, scope for additional analysis. But I think that's right. It is fairly general at this point. We did get comments in that regard, actually, from some of your members, that the protocol is too qualitative and a little vague in some places. So I do acknowledge that there's some more work that we could be doing here, but it's not a clear, it's not like traffic where, you reduce a level of service from A to E and, then you're into the mitigation world. It's just, it's not as cut and dry. And the concept of disproportionate adverse is, is kind of a tough one to begin with. So, so we are intending to put some more work on that. And that's why we did come out and title that second protocol is interim. The analysis protocol is still interim. So we're hoping to refine that as the year goes on. And in that regard, as we work with DEP in their process, they've been doing a lot of stakeholdering, but one suggestion that's come up is perhaps having a technical session for consultants or other folks who actually have to implement and apply these new rules. So if there's an interest there, I'd love to get the word out, maybe through this organization as well, to have a smaller session where we can really get into the weeds on how some of those new tools, will work, and how we're intending to draw some of those conclusions that are put out in the protocol. So.
Yeah, no, I think a lot of folks would be interested in that, and we can definitely be in touch about helping to, get folks interested and just to know that that's happening. So we are at we're at 12:56. So I don't know if you have any closing remarks you want to make before we all go back to our work days.
Go back to our day jobs. No, not really. I really appreciate the opportunity to present. I think it is important. I kind of feel like I say the same words over and over, but I think it does bear repeating. There's some kind of complex concepts in here that we're trying to implement, but the ultimate goal is really to involve, communities that may be facing existing sort of vulnerabilities and may not be able to participate in public processes effectively. So the idea is just to involve those communities more through the MEPA process. So hopefully we can get some traction in that regard. And we are intending to track some of our projects as well for some metrics to kind of see how many projects come in and what they're doing by way of outreach and what what some of the results are that we are going to get through these new protocols. So hopefully we'll be able to bring that back and share that with others as well. But thank you again for the opportunity. This was really helpful.
Yeah, and I think another takeaway I would say is that for a lot of folks who have questions about, how any of this applies to their particular project, probably the best course of action is to just set up a pre-filing meeting, pre-application meeting, so you can sort of talk through the details of your own project and sort of get the latest on what MEPA has seen to date and what has worked well and what hasn't.
Yeah, I think that's right. And we're also offering joint pre-filings with our EJ director as well on Thursday afternoons. You can just send a request to the MEPA box, MEPA@mass.gov, and we will follow up.
Great. Well, thank you again for joining us today and taking the time to talk to us about all this and answer all our questions. And thank you to everybody who attended. It's nice to see some familiar names in the attendee list. And I hope we'll see you at some of our upcoming events, the AMA, or hopefully the gala. I think we're all really missing that in-person networking aspect. So hopefully we'll see you there. And with that, we'll close it out. And as was mentioned in the chat, if you're interested in a recording, just shoot an email to NEWIEE@NEWIEE.org for the link to that recording. And thank you all again. Have a great day.
Thanks so much.